Welcome to Estate Planning 101. Today we're going to talk about wills, trust, healthcare proxies, and financial powers of attorney. I'm going to give you a brief overcap of what goes into basic estate planning, and this is a great primer if we have an introductory call coming up and you want to get ahead of the game, or you're just looking for more information on what foundational estate planning documents you may need to protect yourself and your family. Hi, I'm Nathan Harding, the sole attorney and owner of Somnium Advisory. When you work with us, you're working directly with me. Before I became an attorney, I was a surface warfare officer in the United States Navy. I then transitioned out and went to law school in the evenings while I worked full-time for the Social Security Administration. I then got my start as a litigator in the IRS's Office of Chief Counsel as a trial attorney. And finally, I've decided to bring it all home and help families and business owners here in my community. I want to take a quick second for you to understand that, like many areas of the law, estate planning has its own language. You'll find on this slide some definitions that I think are important to know so that you can learn the players to understand how they all interact in the estate planning world. You'll find this presentation saved on my website under resources, where you can reference back to these definitions at any time. So let's talk for a moment about what happens if you do not have an estate plan. If you become incapacitated, meaning that you are alive but unable to manage your own affairs, someone will need the legal authority to step in and to handle your medical care and your finances. No one, not even a spouse if you are married, can automatically act on your behalf. Without legal documents that name whom you want to act on your behalf, your loved ones will have to go to court to ask a judge to appoint someone. The court will look to the state's default priority rules for whom to appoint when you pass away. Someone will need the legal authority to manage your estate. And as with incapacity, no one can automatically step in. Without legal documents that name whom you trust for this role, a judge will have to appoint a personal representative, also called an executor depending on the state that you live in, to handle everything. And again, they will rely on the state's default rules. Also, if you pass away without an estate plan, your accounts and property do not just automatically transfer to your family. Your loved ones will likely need to go through probate court before they can transfer your accounts and property out of your name and into the names of your loved ones. Exactly who is to receive your estate, though, will be based on the state's default rules. As you can see, failure to create an estate plan is having to rely on the state's rules with drawbacks. Here are a few major ones. The default rules might not reflect your wishes. Without clear instructions from you, confusion and disagreements can arise. And third, implementing the state's default plan requires court involvement. Probate court is a process which means filings and records are open to the public. Also, the process can be both time-consuming and expensive. Now let's take a bit closer look at what the state's default plans might look like, and then later we'll get into some more detail about how you can avoid these challenges by putting together a thoughtful plan in place now. If you leave it up to the state law and the court to decide who will act on your behalf during incapacity, the people who will generally have priority for appointment are in this order. Now, this may vary depending on your state. The law may have a slightly different list to refer to when determining who will wind down your affairs at death. But in many situations, the person who has legal priority to be appointed might not be the one who could actually that you want in charge. And what if there are several people with equal priority, such as children? That uncertainty can lead to conflict, drawn-out court proceedings, and disagreements over who would step into that role. The judge does not know your family the way you do, and without your input, they are left to make a best guess. And even after someone has been appointed, things can still get messy. Without clear direction from you on how medical decisions should be made and how finances should be handled, others, including the court, might question or challenge what the appointed person does. When it is time for the court to determine who is to inherit from your passing, they will look to the state's default priority rules of inheritance. The following is generally the order of who will receive your accounts and property. Again, states vary on this, but this is just a general list to give you an idea. While the state's priority list might not match what you want exactly, it will generally follow your family tree and prioritize close relatives. You may not agree with who is included or with how much each person receives when they receive it, or how it is distributed to them. For example, you may want to include a charity or a stepchild as a beneficiary. The state's default plan will not allow that. You may prefer to divide your estate unequally among your children, but again, default rules provide only for equal shares. If you do not want your loved ones to receive their inheritance all at once, you are out of options. The default plan requires outright distributions. This can create significant problems, especially if beneficiaries are minors, have special needs, or are not prepared to manage a lump sum responsibly. But without a legally enforceable plan in place, state law and the court's decision will control what happens. So how do we prevent the state's default rules kicking in? Well, we create a plan, and I assume that's why you're here. Most estate plans are built around one of two key documents: a last will and testament, commonly called just a will, or a revocable living trust. If you decide to use a will as the foundation of your estate plan, you'll be able to name a personal representative, known as an executor in some states, along with one or more backups in case your first choice cannot serve. This person steps in after your death to collect your accounts and property, pay any outstanding debts, and make sure that your accounts and property go to your chosen beneficiaries. You can also use your will to nominate a guardian for your minor children, which gives you a say in who will care for them if you are no longer able. With a will, you get to choose your beneficiaries and what amounts they receive, and unlike with the state's default plan, your beneficiaries do not have to receive their inheritance all at once. You can include testamentary trusts, a special kind of trust that is funded during the probate process with your will. This allows you to set conditions and timelines for how and when your beneficiaries receive their inheritance. One thing to keep in mind, using a will requires probate court. This means that the court will oversee the process of distributing anything that is in your sole name and does not already have a valid beneficiary designation. While probate can be a public and sometimes lengthy process, having a will still puts you in the driver's seat. You are not leaving things up to the state's default rules. You are choosing who will manage your estate and exactly how your accounts and property will be passed on. The second type of plan is centered around a revocable living trust. A revocable living trust is something you set up during your lifetime and can change it whenever you want, right up until you become incapacitated or pass away. Once it is in place, you will start transferring your assets and property into that trust. That might mean retitling your assets in the trust name now, or naming that trust as a beneficiary on things like life insurance or retirement accounts that you cannot transfer during your lifetime. This process is called funding your trust, and it is what makes the trust actually work when you intend it to. This type of trust is a flexible planning tool that allows you to name yourself as the initial trustee, which is the person responsible for managing, investing, and distributing the trust accounts and properties to your beneficiaries. You can also name a co-trustee and a series of successor trustees to step in if you are ever unable to manage things yourself. A revocable living trust lets you maintain full control and use of your accounts and property during your lifetime, while also laying out clear instructions for what should happen to your accounts and property if you become incapacitated or pass away. A revocable living trust, like testamentary trust and a will, gives you more flexibility than simply leaving a lump sum of inheritance. You can include continuing subtrusts with specific instructions outlining how and when your beneficiaries will receive their shares. For example, a common occurrence is you might choose to distribute a portion of your child's inheritance at certain ages, such as 1/3 at 25, another third at 30, and then the remaining balance at 35. Another option is to give your successor trustee the discretion to decide when and how much to distribute based on each beneficiary's needs and circumstances. One of the biggest advantages of a revocable living trust is that it avoids probate. That means your affairs can be handled privately and efficiently without court involvement, even if the trust stays in place for many years after your death. It is worth noting that because you are the creator and beneficiary of the trust while you are alive, the accounts and property in that trust are still considered to be your own and not shielded from personal creditors. However, with the right structure, the accounts and property held for your beneficiaries after your death may offer some protection from their creditors, including divorcing spouses. Even if you use a revocable living trust as the foundation of your estate plan, you will still need a will, but the will that is included in a trust-based estate plan is a special type of will called a pour-over will. While the goal of creating a trust is to avoid probate, we cannot predict every situation. If there are accounts or property that were not properly funded to your trust, either during your life or at death, a probate court proceeding may still be required. The pour-over will names the trust as the beneficiary rather than the individual people, as with a traditional will, which ensures that those accounts and property are transferred into your trust through the probate process and are ultimately distributed according to the instructions laid out in your trust document. Additionally, if you have minor children, your pour-over will is where you can nominate guardians to care for them if something happens to you. Now let's turn to some of the powers that are appointed. A financial power of attorney lets you choose the person, called your agent, who will manage your finances if you are ever alive but unable to manage them yourself. Without needing court involvement and without relying on the state's default priority rules, it is a good idea to name a primary agent and at least one backup, just in case the primary agent is not available or willing to step in when needed. You get to decide how much authority to give the agent. It can be limited or as broad as you like. A limited financial power of attorney permits the agent to carry out only certain transactions, such as signing a deed at a real estate closing. A general financial power of attorney means that the agent can do almost anything you can do. You also get to decide when your agent can step in. One option is to make the power of attorney effective right away, even if you are not incapacitated. That does not mean you are giving up control, it just means that someone else can help out if needed. For example, maybe you are traveled, deploying in the military, or dealing with mobility issues that might make it hard to handle things in person. Having someone you trust who can step in and can make life a lot easier. Another option is to create a springing power of attorney, which takes effect only if you become incapacitated. You can define exactly how that determination is made, but just a heads up, not all states allow springing powers of attorney, so it's something to check on before deciding. Finally, to make sure your agent's authority continues, even if you become incapacitated, you will want to make the power of attorney durable. This means that your financial power of attorney will still be enforceable even if you are incapacitated. Turning to the medical power of attorney, lets you name someone who you trust, sometimes it is called a healthcare agent, to speak for you and make healthcare decisions if you are ever unable to do so yourself, without needing court involvement or relying on the state's default priority rules. Just as with the financial power of attorney, it's a good idea to name a primary healthcare agent and at least one backup in case your first choice cannot or does not want to serve when the time comes. We'll now turn to a third important document in your estate plan called the Advance Directive, also known in some states as the Living Will. An advance directive allows you to express your wishes about end-of-life care, such as whether you want artificial hydration, nutrition, or respiration to be continued, whether you prefer not to have these measures at all, or if you are in a persistent vegetative state or have a terminal condition with no hope of recovery. These instructions can offer valuable insight into your values and preferences regarding medical care. Because these decisions are deeply personal and often sensitive, it is important to take time to reflect on your wishes. Although it may require some soul searching, understanding what you want in these situations will help ensure that your choices are clearly documented and communicated to your healthcare agent. This clarity can go a long way towards reducing confusion, conflict, and feelings of guilt among your loved ones by giving them confidence in that they are honoring your wishes. Finally, the HIPAA authorization form. This allows you to give specific individuals access to your confidential medical information, such as updates about your condition or copies of your test results, without granting them the authority to make decisions on your behalf. Sharing this information with your loved ones can help ease the anxiety and uncertainty that often arise in a medical crisis. It can also reduce tensions between the healthcare agent, named in your healthcare power of attorney, and the rest of your family by ensuring that no one feels left in the dark. While only your healthcare agent can make decisions, the people listed on your HIPAA authorization form will have access to information that can help them understand and support the choices being made. Now that you have an understanding of the documents that go into a traditional or foundational estate plan, we're going to turn towards the more practical side of estate planning and ensuring that it actually delivers. When you create an estate plan, it is about much more than deciding who will receive your stuff after you're gone. A truly effective plan also includes clear instructions for how your finances and healthcare should be managed if you are alive but unable to handle these matters yourself. To ensure that you and your loved ones have the greatest protection and peace of mind, your estate plan needs to be thorough and carefully prepared. Not just any plan will do. We just walked through the essential estate planning tools that make up a comprehensive plan. These documents address incapacity, end-of-life decisions, and the distribution of your accounts and property, helping ensure that your wishes are honored and your family has the guidance and support they may need when the time matters most. What I will say at this juncture, though, is that an entire comprehensive plan does not need to be created all at once. We can take this in bite-sized pieces to get the most important documents in place as soon as possible. For example, if you have minor children, you are going to want to name name guardians in that will as soon as possible. Same with healthcare proxies and durable powers of attorney. Those can be created separately from a trust or will. Also, for my parents out there with adult children, you may want to have your adult children create healthcare proxies and HIPAA authorizations to name you as their agent so you can make medical decisions in case they are ever incapacitated or are needing help. And on the other side of the spectrum, you may want to have your parents authorize you as their healthcare proxy and name you on their HIPAA authorization without having to touch an entire comprehensive plan. Next, this is not a one and done scenario. As we all know, life changes, families grow, finances shift, and laws evolve. If your plan is not kept up to date, it could end up causing confusion, delays, or conflict when your loved ones need it most. Regular reviews help ensure that your wishes are clear and your plan still reflects what matters to you most. As a rule of thumb, you should review your estate planning documents every 3 to 5 years. Or if you experience a major life change in the meantime, you may want to review them sooner. Some common life events that should prompt a check-in with your attorney: death, birth, marriage, divorce, retirement. One that I like to trigger is a new job. New job might happen every 3 to 5 years. It's a time of change. Might as well take a look at your documents. Make sure they still reflect your wishes. Let's talk about the practical consideration of storing your documents someplace safe but accessible. It is just as important to keep your estate planning documents safe and accessible as it is to create them in the first place. Whether you decide to store your hard copy original documents, make sure that location is weatherproof. If you live in an area prone to fires, flooding, tornadoes, or earthquakes, take steps to protect your documents from damage. You might consider keeping them somewhere in your home. This is often a logical place and one where you would expect your trusted decision makers to look in an emergency. If you store them in a locked-in container, such as a safe, make sure the right people either have the key or know how to find it. If the container uses a combination instead of a key, make sure they know the combination. This is a common misconception and one you see in the movies. A safe deposit box can be a secure place to store important documents, but can also cause issues if your loved ones are not listed as co-owners. Giving someone authority to access the box rather than an ownership interest can be helpful if you become incapacitated, but that actually access usually ends when you pass away. This means that they might not be able to get the documents they need to carry out your wishes. In some states, there are some special steps to open a safe deposit box after someone dies, but it can take time and might involve going to the court. It might also be a good idea to keep your digital copies of your documents. They are often quicker to access in an emergency, and in some cases can serve as a backup if the originals are ever lost or damaged. You might store them on encrypted cloud service or on a password-protected thumb drive, whatever you are most comfortable with. But just like with a safe or other lock container at home, make sure your key people know how to access them when the time comes. Another idea is to provide your trust decision makers with your estate planning attorney's contact information. After you sign the necessary confidentiality waivers, your attorney can provide copies of your documents to your trusted decision makers if and when needed. As we're wrapping this up, another practical tip is to be honest about your wishes. How much you choose to share about your estate plan is entirely up to you, but it's important that your loved ones at least know that you have created one and where they can find your plan documents. You may decide to go a step further and let them know who you've chosen to serve as your trusted decision makers, such as successor trustee, personal representative, or executor, and the agents under your powers of attorney. This helps ensure that they understand their roles and are not surprised if they are called to step in. Some people prefer to be completely transparent and share all the details of their estate plan, including who will receive what. To be honest, this approach usually has the least conflict after the fact. But keep in mind that you will need to update your loved ones if your plans change so that no one is relying on outdated information. If you have not done any estate planning yet, you can also choose to be upfront about that. This honesty can save your family time and stress by preventing them from searching for a will or trust that does not exist. As you can see, creating an estate plan is not just about protecting yourself. It is one of the most thoughtful gifts you can give your family. By putting a plan in place, you make things easier for your loved ones during that already difficult time. You give them clarity, reduce stress, and help prevent family conflict. It's a powerful way to care for people you love, and even when you are no longer here to do so in person. To wrap it up, you can find my contact information here. Reach out via email, phone call, text, however you choose. If you are just viewing this to learn a little bit more about estate planning, I hope you found it helpful. I'm happy to answer questions. And if you viewed this and we have an upcoming appointment, I look forward to be able to dive right in and discuss about your needs, your intent, and how I can best serve you. Thanks.